Okay. Ready?
Yeah.
Good morning, afternoon. This is Ruben Dupay. I represent Charlene Nichols, formerly known as Charlene Weinrich. I'd like to reserve 4 minutes for rebuttal.
Sure.
This is a modification of alimony due to the retirement of the payor. I believe the result of this case is an abuse of discretion because the former wife is being shortchanged by the award of a simple $1 a month nominal alimony. The financial facts are relatively straightforward. The former husband has retired at the age of 70. We're not contesting, although there was some issue made about whether the retirement was necessary or appropriate at the trial court level. We're not challenging that issue on appeal. Leaving his income to be Social Security income and whatever income he could derive from a IRA retirement asset with a $1.4 million balance. The former wife similarly had Social Security income of $1,200 a month net and a retirement asset of $167,000 at the time of trial. The brief laid out, I try to present in a cumulative manner, going opposite the standard of putting your strongest argument forward. I did it more of a building argument.
Could you though take a minute and address the question of waiver, failure to file exceptions to the master's report?
Certainly. I don't think there's any disagreement of the procedure of how, certainly the record, it was a proper referral to the magistrate. The magistrate entered its report. There were no exceptions filed. I believe the case of Webb Clay, which is cited approvingly by this court in 2012 in In Re KM, that there is no legal authority, including the rule about magistrates, that suggests that a lack of filing exceptions is a waiver of right to appeal. I don't believe there's any reason to change this rule now. I think it would be unfair to Ms. Nichols if the court decided to change it on at her expense.
Mr. Dupay, I tend to agree with you that not filing exceptions doesn't constitute a waiver. But a related issue for me is the fact that I guess there was a hearing before the magistrate, and the trial court did not have the benefit of having a trial transcript when he was considering the magistrate's report.
Okay.
And we, I guess we have it now, but that was of no use to the trial court.
Correct. But I'm finding more and more the signing of an order in which no exceptions are filed is essentially an administrative act that the trial court. I guess I've never been in a trial judge's office when he signed one of these, and he or she has signed one of these orders. So I don't know to what extent a judge goes over these orders and looks. It's not common practice, nor is it in the procedural rules, to require a transcript be filed on every report recommendation of the magistrate. It's only required if exceptions are filed, and then again on appeal if an appeal is taken.
So a trial court would have nothing other than the written recommendation and the magistrate's findings and conclusions, correct?
Yes.
Which on their face appear regular?
Perhaps.
And if I let me shift to something else. If I, would you concede the magistrate did consider the minimum distributions that the former husband had to take from his IRA?
I don't concede that point, Your Honor. I think it's ambiguous whether or not the court considered it. It clearly said in paragraph 18 that it was following I believe improperly following the Gilliard case. That case law further states any further use of said asset would be in effect double dipping. However, the court then at the very end does state, even if you allow the court to consider petitioner's tax qualified plan for alimony purposes after it has already been split, the petitioner's income does not allow him the ability to pay respondent's alimony. So I think that's a cover the basis paragraph 32 is just covering it in the event.
I thought he specifically made a point of noting that I guess the minimum withdrawal amount would be what, 50 grand, 55.
Yes.
And I guess that in the grand scheme of things wouldn't make a difference in the financial situations of both parties.
That touches on the issue. Well, the magistrate made that finding in the transcript that she was going to include the 55,000 minimum distribution as income to the former husband. However, the order doesn't make it that clear. The order changes, I believe. Paragraph 18 distinctly changes from the position the magistrate took in the oral ruling.
So is your position that the magistrate and the trial court should have required the former husband to dip into his IRA to pay more than what would be normal income coming from it?
No, that's not specifically my position. I'm not arguing there was error for the trial court not to do that. My argument is that I'm kind of blending. I believe that Kitchens and Niederman need to be explained in concert. Kitchens makes it clear that even if the mandatory minimum withdrawals requires dipping into principal, so if there is a principal component of that, we're going to still include that in income because it's mandatory minimum withdrawals, and the whole purpose of that mandatory minimum.
But we have to, the IRS tells us we have to do that.
Correct. But what I'm suggesting is that kind of sets the floor. But Niederman, in my opinion, sets the ceiling of what the income could be. And if you have a $1.4 million asset and you're in the first year in which you've had to take that mandatory minimum, it's quite possible that the income derived from that $1.4 million asset is higher than the mandatory minimum, and that there's more income than there. And so I believe that the trial court should be clear that income's income, and if income's lower, it's caught by the Kitchens kind of floor. So we're going to go with the mandatory minimum or higher if actual income can be proven to be higher than the mandatory minimum.
But at the posture when it was before the magistrate, there was nothing that was known about what future income is going to come from that IRA other than in this particular tax year, it was about a $55,000 mandatory withdrawal.
Correct.
So what is the magistrate going to do when that's all he or she has?
It was flushed out as part of the former husband's testimony that the only discovery documents he provided leading up to trial about his retirement asset was a statement from his employer-based profit sharing plan. He didn't provide any statements. He rolled it into an IRA with Charles Schwab, and he didn't provide any statements in discovery from Charles Schwab to show what happened from when he rolled it in approximately April of 2018 through the time of trial in March of 2019. So there was no evidence available to the former wife to present to show what his actual income over that particular year would have been. You contrast that to the former wife provided statements, put statements in the record showing what her income on her, what was at the time of filing, $220,000 retirement asset, showing that it lost money in all of 18. And then the trial court applying a different standard. And that also bothers me. One, the trial court violated Acker by paragraph 18 and trying to apply Gilliard, which shouldn't apply to someone in retirement as opposed to at the time of divorce when they're younger. And second, the trial court had a different standard for the wife's income than the former husband's income. The trial court, in my opinion, made it very clear in paragraph 18, we're not going to double dip. We're not going to consider this $1.4 million retirement asset to the former husband, but we will double dip and consider the income derived from the what's remaining of that same asset. It was the same asset that was split. The former husband saying, you can't count income from my half, but count all the income from the former wife's half. That's tacitly unfair.
But if she's taking out $3,000 a month, as she's withdrawing money, that's income because she's taking money out of the IRA. And if the magistrate said, well, for purposes of the former husband's income, you're taking out $55,000. So I don't quite necessarily follow your point.
The
$3,000 IRA in some sense.
The $3,000 the former wife was taking, the amount someone withdraws from an IRA, my reading of Niederman and Kitchens and trying to consolidate those theories, the amount someone withdraws from an IRA is not specifically the income the trial court should use. The income should look at an IRA just like any other investment vehicle. It's an investment account with tax deferred status. And if, as long as that person is 59 and a half and they don't pay a penalty, they can access that income. They pay tax on it, just like they do if they go to work, but that's gross income available to them to support themselves or potentially pay support to someone else. So the distinction is the law is clear that we shouldn't require someone to invade principal, whether that's on the payor side or the recipient side. Okay, so we've still got this asset that has an income. So if the former wife is invading principal by taking that $3,000 a month, that's not income to her. That should be included in her need analysis. And
Let me ask you a question. Okay, so if I understand what you're saying, the court should have imputed the minimum of $55,000, right? That's what you're starting at?
right, for the former husband.
And in addition to that, looked at the net income on the Social Security?
Yes, ma'am.
Okay, so if I tally those up, oh, I have my notes here, somewhere, over 90 some $1,000. Is that what you're looking at as far as annual income?
Yes, and then he testified that his expenses per month were around $8,000, which was more than what he had in his financial affidavit, but the trial court allowed him to kind of supplement it.
Now, the 55,000 minimum, that applied to him because of his age,
Yeah.
right? On the IRS regs. Okay, did the same apply to the former wife?
No, I believe she was 69 at the time of the trial. Her financial affidavit, and I cited that in my brief, said 68, so I used 68, but I think she was legitimate with 69, which is the.
So when you're talking about the withdrawals that she was taken, am I understanding that we don't impute that as income because they're discretionary and they weren't, because the laws don't provide that they have to be imputed with the minimum income of 55?
I guess I'm taking a different approach. I'm suggesting the amount of withdrawals.
I may be confusing it all, but okay.
I'm suggesting the amount of withdrawals have no relevance whatsoever to what the income is on the account. The income is the income, whether it's growth, capital growth, or in dividends, etc. But that should be a separate calculation, regardless of whether she's withdrawing $0 or all of it. So the amount of withdrawal isn't directly related to how much income that account can give.
Okay, I understand. Thank you.
The other point about the former husband's income is that the court, there was testimony or evidence provided by his tax returns that his current wife is receiving Social Security, and there should have been some offset from the expenses, albeit maybe $1,000 a month. My whole point in bringing that up is when you include that in the analysis, I believe the facts show the former husband is operating right at level to meet his needs. His income, when you include the types of income Your Honor just mentioned, plus offset his expenses slightly for his current. Well, I'm sorry, I went to former wife. His current wife's income. He's operating right at a standard where he can meet his needs. And
so what is the former wife? And so what is your argument as far as what is the former wife's income as to what her income was, not need, but income?
The former wife's income is what her Social Security is, which is $1,200 some odd dollars per month net. I don't have it right in front of me.
46, yeah.
And then in my brief, I laid out, if you looked at her 2018 statements for her retirement account, her IRA or two IRAs, which they're all in evidence. They were all admitted into evidence. That account actually lost money on the year. There was some income, accounting income, dividends, interest, etc. But there was an investment decline throughout the year. So even ignoring the distributions that were made, that was operated at a negative in 2018. But then in 2019, for the 3 months before trial, it operated at a positive for $12,000. If you look at that 15-month period in combination, it's like a $6,000 gain over 15 months. Or if you do a roll, I didn't do the rolling kind of 12 months, March to March. So I don't know exactly what the income is from that account. Even if it were, say, $1,000 a month, she's at $2,200 a month. Even if $1,000 a month net were the income, which I don't think it is, she'd be at $2,200 a month net with $8,000 or so in expenses. Clearly, she's operating at a significant deficit when you detail her income over her expenses. And whereas the former husband's operating at a break even.
When you say her expenses, I mean, because we have the ability to look at what her expenses are, the $8,000, I mean, a lot of those are necessity items, right? You'd agree with that?
I don't know. I haven't interviewed her on that regard.
Well, don't we have the benefit of that in the record to know what some of those credit card bills are, right?
Perhaps the credit cards, she testified that the credit cards were increased when she stopped receiving her alimony in April.
Those are included in the calculation though of her $8,000. You're including those, right?
Yes, I believe so. I would make 2 points about her expenses and whether or not each of you nitpick those expenses to be necessary or not. One is the standard, according to Dunn, still needs to be, some consideration needs to be given to the standard of living as addressed at the marriage, and which, according to the negotiated settlement of alimony, require her to receive $6,750 per month in alimony. Two, even if you look at the former wife's bank statements, which were also admitted into evidence, kind of in volume, if there was 5 months which were admitted, I think it was January through April or May of 2018, which she was spending on average $9,500 per month while she was getting alimony. And then when she stopped getting alimony, her average went down to, I think, $7,500 or about $7,000 a month. So the evidence is in there, and it can be, pulled out that she was still spending she had that need. She was still spending, every dime of her alimony on expenses. Good, right or wrong, she was living with that standard of living and maintaining it. So there's no evidence that she kind of voluntarily pulled it back, unless you include the time in which she's no longer receiving alimony. And I don't think that's fair to hold someone against not overspending when they're at $6,750 worth of alimony per month. Is just
Mr. Dupay, you are into your rebuttal time. Use it as you wish.
all right. I'll break that. Thank you.
Okay. Ms. Kavanaugh.
Thank you. Good morning. May it please the court. Shana Kavanaugh on behalf of the appellee, Richard Weinrich. Your Honor, it is our position, even though Your Honor stated that you don't believe that the exceptions are a necessary part of the process, I would argue that it still is a necessary part of the process. When the court signs an order of referral to the magistrate, the order of referral specifically states that you must file, if you want the report and recommended order of the magistrate reviewed, you must file exceptions. They consented to the use of the magistrate. Then the recommended order, the report and recommended order was issued. It specifically stated what the exception period of time was. They didn't file exceptions and the court adopted it as an order of the court. If we are allowed to skip that process, what's the point of the rule? Why even have the language? Why even have an exceptions? This court would be inundated with appeals on cases that could potentially and probably are resolved by a trial court. In Edge v. Edge, the court said that the court held specifically that exceptions are a necessary process. If the cases that are cited by Counsel Dupay, they all involve fundamental issues of law, which are quite different than the case at bar before this court. The issues before this court are all discretionary issues. The cases that are all cited by Mr. Dupay and the cases that say that don't ultimately give a reason why exceptions aren't necessary, but all involve fundamental issues, fundamental constitutional issues, due process issues. That is not the case here. So I believe there is a universal understanding and appreciation of the rule and the interpretation of the rule on orders of referral to the magistrate that a necessary process before proceeding to an appeal is filing exceptions. And if this court says that that is not necessary, then this court is going to be faced with appeals from all these cases that are probably being resolved at the trial court level and not making it to the appellate court. That being said, I understand you disagree. Substantively, if the court finds that exceptions are not required, substantively, I believe that the magistrate made all the requisite findings, found the evidence, used her discretion, determined that there was no longer a need. The magistrate determined that the mandatory minimums included an income. She might have articulated verbally at the orally at the date of trial, but she did incorporate that into the order because she specifically stated in paragraph 22 that the 32, that even if you allow the court to consider the tax qualified plan, he still doesn't have the ability to pay. Even if, so the court did ultimately consider that, did ultimately utilize the mandatory minimums. He should not have to be forced to invade his principle to pay an alimony award where there was clearly a substantial change in circumstances of his retirement, which is not in dispute, and nor is it been argued by.
Ms. Kavanaugh, I don't hear Mr. Dupay suggesting that he has to invade his capital. I think what I understand is there should be a more in-depth analysis of what the income is on a yearly basis or a monthly
beyond
basis.
beyond the RMDs.
Beyond the minimum withdrawal.
Right.
But none of that was done before the magistrate. Am I correct? All we knew is about the 55,000 minimum withdrawal.
But that was his testimony. His testimony was that his income, was the mandatory minimum. They didn't present any contrary evidence that he was drawing other income from it, that he was receiving any income from it.
That it was earning more income than the RMDs. What was that evidence?
They never,
because even if the account doesn't earn more than the RMD, you still got to make the RMD, correct?
Correct.
And in a perfect world, the minimum withdrawal is supposed
would
to
equal
the amount of
or be
income
less
that you
than
earned in that calendar year.
Correct. There's a formula to determine the mandatory minimum, and so the former wife did not present any evidence that he was taking any additional income or receiving any additional income from his IRA, and
was there evidence of what the IRA was earning, notwithstanding the RMD?
Correct. There was she presented no evidence in that regard. And so the only evidence that the magistrate had to rely on, and which it did, was the mandatory minimum withdrawal.
Well, there was some argument, as I recall, as to whether the value was 1.2 or 1.4, but I'm not sure that tells us that there was any increase in the IRA. I think it was just, as I understand, it was just an argument as to what the value was and was it properly reported.
Agreed. And I believe that ultimately at the end of the day, whether it's 1.2 or 1.4, I mean, had there been evidence that there was more income that he was entitled to or he could be receiving from it, would have made a difference. But at the end of the day, because none of that evidence was presented, I believe it's harmless error regarding whether it's 1.2, 1.4. It had no bearing on the ultimate outcome, and the evidence that was presented and the unrefuted testimony that was his income. It was the 55,000 mandatory minimum. The court, and so it's our position, it's the former husband's position that the court utilized the correct analysis, that it's in the determination is completely discretionary. The court used its discretion in based upon the evidence and the testimony that was presented at trial. And based on that evidence and testimony, the court determined that the former husband did not have the current ability to pay the ongoing alimony obligation. And and reduced it. The court left the door open for the former wife. It didn't completely do away with her ability to come back to court should the circumstances change again. The court granted her $1 to leave the door open should, whether she depletes her retirement or maybe his income goes up from the mandatory minimums. But based upon the evidence that was presented at trial, the court properly applied that to within her discretion and made an appropriate finding. And the former husband is asking that this court affirm the order granting the supplemental petition.
Thank you, Ms. Kavanaugh.
Thank you.
Mr. Dupay, you got 4 minutes.
Thank you. I want to take right off on that point. The former wife is left in a position where she will have to invade principal just to meet her basic living expenses. She will have to pull down that IRA that she has, and she will be put in a position where she has to go back to court seeking an increase. And at that hearing, the former husband's counsel is certainly going to hold up paragraph 18 of this order and say, you can't look at that IRA, it would be an impermissible double dip, and it's now res judicata that we don't have to look into that IRA. So if nothing else, this court needs to be clear that on any future issue here, Acker is the standard that needs to be followed, which specifically says that is not an improper double dip, and his IRA can be considered as a source of either income or a source of ability to pay. Further, I want to point out that the former wife was shortchanged here. She was put in a position where she is clearly without the ability to meet her own needs, where she only has $167,000 in a retirement account to continue. She's 70 years old, 69 years old. She's going to live another, 15, 20 years, and that's all she has. The former husband is left in a position where he can specifically and pinpoint actually meet his needs on a monthly basis, and he's got a $1.4 million kind of safety net as far as that IRA is concerned. Now, I looked and I looked and I looked. When I was a baby lawyer, I read a case once, and I can't find it now, but it talked about when there's not enough.
Tons of those.
I know. When there's not enough income to go around, you can't just say, well, there's no ability to pay. The husband still operates at a deficit. There's not enough to meet both. So, the recipient takes the short end of the stick, where that case said, hey, we got to trim both, neither party can meet their needs. So we're okay with entering an amount of alimony that doesn't allow the payor to meet their needs because neither one of them can. And I think with 6108 and the fact that it allows you to look at assets of parties, I think it would have been fair. And even if it meant the former husband had to take a slight deficit from his monthly expenses, some amount of alimony should have been awarded to offset the former wife's needs to some extent. I don't think she was even arguing for the full $6,750 as a result of this trial, but something needs to be there to help her out. She's left in
even if I, you raised a point earlier about the former husband's new wife, and I don't know on what basis you would allocate any of her Social Security, but if you take even what you suggested, as I remember the numbers, everybody's still underwater.
Just a slight extent. I think that what I was arguing is, to the extent that $8,000 a month budget the former husband has includes expenses for meals and things for his new wife, who's living under the same household.
Or to the extent that her income contributes to his expenses.
Correct. Well, he didn't.
You can't impute her income to him, but the expense allocation can be taken into account.
Yes, sir.
Right.
That's what I was suggesting. So I believe I was wrapping up. I think I touched on all the case law I wanted to mention. I know we added a little issue at the end about retroactive alimony I just to vocalize it out loud. When you looked at his income in 2018, although his income stopped from his employer in April, if you look at it on a whole for the calendar year, he still made a net income of around $200,000, which left him ability to pay something, and perhaps it shouldn't have been made retroactive all the way back. To the extent the court is able to reverse, we'd ask that the trial court be able to look back at any potential alimony award be made retroactive to the date of filing or the date she stopped receiving her alimony. Unless there's any further questions, that's all I have.
Okay, thank you, Mr. DePay. Thank you both very much. In order to leave, you need to click the button in the